Look, the provisions on witnesses are not only found in Rule 130. You connect it to Rule 132 because most questions on witnesses are there. Look at Section 3 of Rule 132. Suppose a witness is asked, Mr. Witness, is it not a fact that you borrowed 1 million from the plaintiff and that you still have not paid the debt despite demand upon you? He says, I refuse to answer, Your Honor. Can the court order him to answer? Look at Section 3, the first part. The answer is yes. Even if his answer would establish a claim against him or a liability against him, he must answer. He cannot invoke the right against self-incrimination. Because if he answers, he will not be open to a criminal prosecution. Because it's about a debt. It's about utang. Admitting a debt will not give rise to the right against self-incrimination. Because no one can be imprisoned for debt or non-payment of a poll tax. That's your Philippine Constitution. But if you are asked, is it not, Mr. Witness, that before you testified here, you pointed a bazooka at the plaintiff? Can you refuse to answer? Yes. Because that answer would subject him to a penalty for an offense. You look at Section 3, you go to number 4. There, the right against self-incrimination would come into operation. If your answer would open you to a prosecution for an offense, you cannot be compelled to answer. The right against self-incrimination is a right in relation to testimonial compulsion. It does not apply to extracting physical evidence from you. You cannot invoke the right against self-incrimination if the court orders you to subject yourself to a physical examination, a DNA examination if the court orders you. You cannot invoke the right against self-incrimination because it is not testimonial compulsion. When you were in the first year, you studied that famous case of Villaflor versus Summers, where the woman was accused of adultery. And the prosecutor moved for the physical examination of the woman. That if the woman is pregnant, she has committed adultery. The woman went to the Supreme Court. She said, right against self-incrimination. I will be furnishing evidence against myself. The court said, it's not furnishing evidence against you. It's simply discovering an evidence. The evidence is already there. If you are pregnant, it's already in your stomach. The right against self-incrimination does not include physical examination. Okay? But even if your answer would subject you to a criminal prosecution, if you, under the law, is entitled to immunity, you cannot refuse to answer because you are immune. Remember the two kinds of immunity? Transactional and use derivative immunity. Another point, the right against self-incrimination of an accused is different from the right against self-incrimination of an ordinary witness. An ordinary witness cannot refuse to sit on the witness stand. Before he can invoke his right against self-incrimination, he must first wait for the question. Only when he has heard the question can he say, I refuse to answer and invoke my right against self-incrimination. But the accused, in the exercise of his right against self-incrimination, can totally refuse to testify. Remember the case of Samson versus Beltran? Okay? This guy was accused of forgery. There was no other evidence against him, except if he gives a sample of his handwriting. He refused. The court said that's a violation of his right against self-incrimination. Although many do not agree with this because the court said giving a sample of your handwriting is not a mere mechanical act, but it requires volition and intelligence. But the real reason given by the court is beautiful. Right against self-incrimination is, I cannot be compelled to testify against myself. But there is no other evidence against the accused except a sample of his signature. So he will be producing evidence against himself. That's the reason why the court said it's a violation of his right against self-incrimination. But had there been other evidences against him, the sample signature will not be the reason for his conviction. It will only be corroborative. In that case of Samson versus Beltran, no other evidence exists except if he gives the signature. Now, one very important concept here is Section 6 of Rule 132 on witnesses. What can you ask a witness on cross-examination? Can you ask him matters which he did not mention in the direct? The answer is yes, if it is related to what he mentioned in the direct. But if the question tests his accuracy, his truthfulness, his lack of bias or absence, or with bias or interest, you can ask him. Anything that relates to his credibility could be asked. Anything in relation to the issues of the case could be asked. It is not correct to say that he could only be asked questions on matters he mentioned in the direct. Section 6 is very broad. Sinabi niya sa testimony, 5 tao ang pumunta sa bahay ko nung gabing yun. Hanggang doon lang. Pwede ba siya tanungin? Sino ang mga tao na yun? Sagot ng kabila, objection. Wala naman siyang minention tao eh. Kung ang identity. No, he could be asked because it's related to what he testified. He could even be asked anything that relates to his accuracy of perception, his truthfulness, or anything about the issues of the case. But if the accused is the one testifying, you can only ask him questions on what he testified in his direct. The accused cannot be compelled to testify, but if he testifies, you can only ask him questions on his direct exam. That's not evidence, that's criminal procedure. Could you go to Rule 115? Is it letter D? Yes. You can only ask him questions on what he mentioned in the direct exam. Okay? You must also know the meaning of leading questions and misleading, okay? Diba, wala nang direct examination ngayon as a general rule, except in some criminal cases, okay? You have judicial affidavit, right? Even in a judicial affidavit, you cannot ask leading questions because that will be subject to objection. Because the one who executes the judicial affidavit is still subject to cross-examination. What is leading? Leading means it suggests the answer to the witness. When you ask a series of leading questions, it is not the witness who testifies, it is the lawyer. So I took to Lizette here. Madam Witness, is it not a fact that Miss Sandoval borrowed 50,000 pesos from you last year? Yes, sir. And 1 month after, she borrowed another 50,000? Yes, sir. And another month after, she borrowed 50,000? Yes, sir. And the next month, she borrowed another 50,000? Yes, sir. So that's a total now of 200,000? Yes, sir. And the next month, she borrowed 500,000? Yes, sir. So that becomes a total of 700,000? Yes, sir. And is it not that the due date was last month, at the end of the month? Yes, sir. And you demanded payment upon her? Yes, sir. And your demand was in writing? Yes, sir. And she received the letter of demand? Yes, sir. And she signed for it? Yes, sir. And until now, she has not paid? Yes, sir. That will be all for the witness, Your Honor. Who is testifying? The lawyer or the witness? The lawyer. You couldn't ask those questions. It's like this. He said, do you know Martha? Yes, sir. How did you come to know her? We were classmates. Is that all the reason you know her? No, sir. She's my friend. And in the course of your friendship, what happened, if any? Oh, she borrowed money from me, sir. How much did she borrow? See, that's not leading anymore. Asking leading questions is unfair. But can you ask leading questions sometimes? Yes. In the introductory portions, preliminary questions. It's not wrong to ask leading and preliminary like this. He said, you are a police officer, right? Yes, sir. That's leading. But that could be asked. Another leading question allowed indirect is if she is a hostile witness. Because in a civil case, she could call the other party as an adverse witness. She's hostile, of course, there. He could ask direct and leading questions. By the way, you will become lawyers soon. In cross-examination, the best questions are leading. Okay? Leading questions are okay. The best questions in cross-examination. Hindi bawal ang leading sa cross. Ang bawal sa cross ay misleading. Assuming something that has not been mentioned by the witness or assuming something that is not in evidence. Tinanong ko halimbawa si Lizette, when the car accident happened, where were you seated? In front or at the back? In front, sir. Bigla kong tinanong, how fast were you driving? Misleading him. She did not say she was driving. She only said she was seated in front. She could be a passenger, she could be the driver, but there is no evidence she was the one driving. Okay. Do you quarrel, Marge, with your husband sometimes? She said, yes. How many times do you hit him on the head? Oh, misleading. Why? She only said they quarrel. There is nothing in evidence which says he hits him on the head. Oh, ganito, iba. What do you do when you quarrel? I hit him in the head. How many times? Oh, isa ka pala how many times. Pero yung ina-assume ko na pinapalo niya ng rolling pin sa ulo, ay misleading yun. Bawal ang misleading sa cross. Pero maganda ang leading sa cross. You do not say, sa cross, will you explain? Ay di inubos niyang oras. You do not say, why? Di mag-explain. See? The modern cross-examination now is not to be hostile to the witness. It's simply very like this, Mr. Witness. You are testifying right now because you saw the killing, right? Yes, sir. And I assume you remember every detail of what you saw. Yes, sir. And even if this happened at night, at 9 o'clock or 9:30 in the evening, you still remember the incident vividly because the crime was committed underneath a well-lighted Meralco lamppost. Yes, sir. And you remember even the knife he used. Yes, sir. And I assume it was around 11 inches, stainless. Yes, sir. And the handle was colored brown. Yes, sir. And I assume you remember the shirt which the accused was wearing. Yes, sir. White. Yes, sir. With the name Nike on the chest. Yes, sir. And with the words "No Fear" written on the back. Yes, sir. And you also remember, I know, the pants he was wearing. Yes, sir. Was it Levi's? Yes, sir. And it was Levi's 501? Yes, sir. You remember the shoes? Yes, sir. You remember everything because you saw it, the incident? Yes, sir. And he was wearing an old Adidas Fred Perry? Yes, sir. That will be all for the witness, Your Honor. He's lying. And the judge knows that, or you tell the judge about it in the memorandum that you file later. Or if he likes oral argument in your oral argument. He's lying. The ones he testified to are too detailed. You don't observe what is written on his chest when you see a startling occurrence like a killing. You don't pay attention to the brand of his shoes or to the brand of his pants. You don't even say, uy, 11 inches yun na nga ba? You don't. Uy, ang puluhan, kulay brown na. You don't even see it. It's just a blur to you. The truthful witness will say, I don't remember those details, sir. All I saw was that he stabbed him repeatedly. That's a witness. The one I talked to just a few minutes ago is lying witness. So when you become lawyers, you ask a lot of details, which a person who is telling the truth could not remember. But the person telling a lie will appear to be very, very accurate. Okay? But one important thing I want you to understand is Section 11, impeaching a witness. When you impeach a witness, that means you are destroying the credibility of the witness. Okay? How do you destroy the credibility of a witness? Can you destroy the credibility of a witness by showing his bad moral character? Remember, we're talking about witness. Answer is no. Character is not a mode of impeachment. If you look at Section 11, you will not see the word character. What you will see is a bad general reputation, not character. That's why if a witness is impeached because of his character, object. It's not a mode of impeachment. Okay? Look at the way a witness is to be impeached. By contradictory evidence. That's common sense. Okay? If the witness says false, you say it's true. That's contradictory evidence. But what is important is the second and the third. Let us say a witness testified and you want to impeach a witness by his reputation. You have to call a witness who is familiar with the other person. Because you cannot testify on the reputation of a person if you have no familiarity with the reputation. So it's like this. Mr. X, do you know Mr. Y? Do you want to testify in this case 2 weeks ago? Yes, sir. How do you know him? Sir, he was my childhood neighbor and we're still neighbors until now. Where do you live? We live in the same barangay, sir. We even studied in the same school up to college. From elementary up to college, we studied in the same school. And we are next door neighbors, sir. And we have been next door neighbor ever since. Now, suppose the question is, what can you say about his character? That's subject to objection. Because character is not a mode of impeachment. You get it? What can you say about his character? That's subject to objection. Because, again, let me say, character is not a mode of impeachment. What can you say about his reputation? Oh, that's correct, okay? An answer. Well, sir, he is very troublesome. He is very quarrelsome. He is annoying. Will you object? The answer is yes, even if the topic is reputation. Because the reputation you have to talk about are the ones mentioned in the rules. Truth, integrity, honesty. Not being quarrelsome, not being annoying, not being aggressive. But there are specific aspects of reputation you have to talk about. I will just rearrange it. Honesty, integrity, and truth. Not every reputation is the subject of impeachment. Did you see it in section 11? Okay. Another. Suppose you say, Mr. X, do you know the witness? Yes, sir. He was the one involved in the robbery 6 months ago. Is that all? No, sir. He was also involved in robbing a 99-year-old woman. He was also the one involved in a bank robbery. Are you objecting? Yes. You cannot impeach a person by evidence of specific wrongful acts. You look at the last part of section 11. The wrongful act must amount to a conviction. If it is only a specific wrongful act which does not amount to a conviction, you cannot impeach him on that ground. Now, suppose I ask him about his conviction, Mr. Witness, is it not that you were convicted so and so? Okay, you could ask it if there is conviction. But if it is a simple wrongful conduct, you cannot. Now, one way of impeaching a witness is pointing out a contradiction between his statement while he is in court and before he was in court. Okay? In other words, at some other time, he said something that contradicts what he is saying now in court. So suppose after the investigation, he said that it was Mr. X who actually beat and ran the red light. That was during the investigation. He told the police officer. During the trial, he said it was Mr. Y, the other party, who beat the red light and ran the red light. Is there a contradiction? Yes. How are you going to impeach him? Are you going to call the police officer immediately to testify on what he said during the investigation? You are not going to do that. You are going to ask him about the contradictory statement, ask him to explain, ask about the circumstances, including the persons present, etc. You let him explain. If he denies it, then call the police officer. You call that laying the predicate. You have to go to section 13. In case of prior inconsistent statements, you have to use section 13. You're going to let him explain. Even a contradicting witness is given due process before you are impeaching him. Let him explain. Section 13 goes hand in hand with section 11. Section 13 is laying the predicate. It's not laying the basis. Laying the basis is under the best evidence rule. This is laying the predicate. Okay, so think about that, okay? Impeaching a witness. Okay, can I say it this way? I am talking to my witness. Let's assume this is a direct exam, not judicial affidavit. Suppose I say, Mr. Witness, what's your name? Jose Reynoso, sir. How are you related to the Jose Reynoso, which was given the Golden Leaf Award by the President of the Philippines for returning $200,000 to the tourist who lost it? I am the one, sir. How are you related to the Reynoso who helped an old man when the old man fell from a building and because of his help, he survived? Sir, I am also the one, sir. How are you related to that Reynoso who single-handedly battled 50 Abu Sayyaf gunmen? Sir, I am the one. Can you ask that? Pinapopogi mo ang witness mo? You cannot. You can only ask those questions if he has already been impeached. We look at section 14. You cannot make him pogi. You wait until he's impeached. Then build up his character. Okay? Now, you have presented the original. Let's say the original was not lost. Will it now be admissible? Kung ikaw ang kalaban, meron pa bang pwedeng sabihin ang kalaban laban sa dokumento mo? Sasabihin ng kalaban. Sasabihin mo ano pang ihihirit mo, boy. Ito original na nga hindi ito secondary. Depende sa purpose mo pag-offer ng evidence, hihirit pa ang kalaban. Ang isasagot niya, it is not enough that you presented the original. You must authenticate it. You are offering it as the real deed of sale. In other words, you're offering it as an authentic deed of sale. You've got to authenticate it. Every document, as a rule, or an object, must be authenticated. It means simply this. It must be shown to be that which you say it is. That's why the best evidence rule is not studied in isolation. It has to be studied in relation to documents and rules. That's why you've got to jump to Rule 132. You start with Section 19 of Rule 132 because depending on your purpose, you are supposed to authenticate the document. Now, you will notice there are two kinds of documents for purpose of presentation in evidence. One is public, the other is private. At least you've got to identify and try to know in a case problem whether it is public or private. You will notice too in Section 19 of Rule 132 that public documents do not only refer to the official acts or records of official acts of our officers, tribunals in the Philippines, but also the foreign country. You will see that in letter A, also the foreign country. You will also notice that an authorized document becomes a public document if it is notarized. The only document that remains private, even if it is notarized, are wills, last wills, and testaments. Even if they are notarized, they remain as private documents. Now, okay? By the way, those are the kinds of documents for one specific purpose. Look at Section 19, for purpose of presentation in evidence. Now, how do you authenticate the document? You go to Section 20. Now, let me ask you one question. Do you have the obligation to authenticate every private document? No. Only when that private document is offered as authentic are you going to authenticate it. See? Look at Section 20. When you offer a document as authentic, then authenticate it. If you are not offering it as authentic, go to the last paragraph of Section 20. You only have to identify it. Oh, let me check on this, okay? Let's check this out. Sinabi ko sa hukuman, ako po'y nahulog sa hagdan dahil naapakan ko ang isang dokumento, ang title ay deed of donation. I only have to identify yung naapakan ko na deed of donation. I don't have to authenticate it because I'm not offering it as authentic. I'm offering it for a different purpose. Na yun, ang natapakan ko kaya ako nadulas. I will identify it. Ito yung tinapakan ko kaya ako nadulas. The other party says, authenticate it. Answer, ulul. Why are we going to authenticate it? It's not offered as authentic. Now, how do you authenticate a document? Private document. Can I authenticate that document by saying, I saw it executed? Yes. Yan ba ang tunay na tinirma nila? Oh, nakita ko eh. That's the first. The second is, you prove the genuineness of the handwriting. Did you see that in Section 20? Yes. Those are the two ways of authenticating. Now, question. Do you need a handwriting expert to prove the genuineness of a document? No. Look at Section 22 of that rule. It does not require an expert. An expert will help, but expert testimony is not indispensable. Look, this is very simple. You don't have to memorize that word for word. Oh, masasabi ko ba na yan ang signature ng tatay ko dahil familiar ako sa signature niya? Yeah. Masasabi ko ba na yan ang signature ni Jose Pidal dahil nakita ko siya, siyang pumirma? Yeah. Yan ang Section 22. Or the court can even make comparisons between the genuine signature and the specimen signature and the one offered in court. You don't need an expert. So look, authentication is only required if you're offering the document as authentic. Okay, next. What is the advantage of having a public document? Answer, its authenticity is presumed. Its genuineness and due execution is presumed. With respect to notarized documents, it is because of the acknowledgement. But there is no such presumption on private documents. That's why you have to authenticate a private document that is offered as authentic. But you have to prove the genuineness and authenticity of a last will and testament even if it is notarized. Because it remains private even if it is notarized. Okay? The provisions in public and private documents are simply codal. But there is one thing I want to call your attention to. Suppose in an essay question you are asked, when is a private document offered as authentic, or when do you need not authenticate a private document that is offered as authentic? The rule is, when a private document is offered as authentic, it has to be authenticated. What are those instances when authentication is not needed? Well, let's change the question to make it more understandable. When is it not required to authenticate a private document? To make the first answer very obvious. Number one, when that private document is not offered as authentic, you only have to identify it. Number two, when it is an ancient document as defined in section 21, it's about the age. Look at the age of the document. It's not 30 years. It's more than 30 years. Look at the condition of the document. No alterations, no blemishes, no circumstances of suspicion. Look at the one who has custody of the document. It should be in the custody of someone who, in the ordinary course of things, should be in custody had it been genuine. You don't have to authenticate those kinds of documents. They're called the ancient documents. Or another instance, when there is no need to authenticate a document that is private, when its authenticity is admitted by the adverse party. What are the ways by which the authenticity of a document is admitted? Go back to civil procedure. One is, if that document is an actionable document and you don't deny the genuineness and the due execution of that document under oath, you are admitting its genuineness and due execution. It's the same as saying it is authentic. Another one, if there is a request for admission by the adverse party and you admitted it as genuine under Rule 26, or you did not care to answer the request for admission by the adverse party under Rule 26, there is an implied admission. Look at Rule 26, there is an implied admission there. You see, this is what we call trying to know the connections among rules. Another is, you actually expressly admitted it as genuine. Okay? You will notice that when you talk about the document, you cannot escape talking about public and private and authentication of documents. Now, how do you authenticate electronic documents? You go to Rule 5 of Rules on Electronic Document. This is what Dean Albano says, a provision that is vague. That's true. It talks about a document being digitally signed. Then you must have followed the security measures for that, and that anything that will show to the court about the integrity of that document. Look at Rule 5. If the evidence is not admissible, either because it is irrelevant or not competent, you have to object. Because if you don't object, it will be made parts of the record of the case. The court will not say, this court on its own motion objects to the evidence because counsel does not talk. The court will never say that. Now, question, when do you object? What's the proper time to object to an evidence? Answer, when the evidence is offered. Any objection before the evidence is offered is premature, because there is yet no evidence if it is not offered. The marking of the evidence as Exhibit A is not yet evidence. It only becomes evidence when it is offered. But by the way, under the new rules on pre-trial, every exhibit, object, or documentary has to be identified and marked in the pre-trial. The marking is not now during the trial. It's in the pre-trial. If you do not have it identified and marked in the pre-trial, upon proper objection, the court will not allow you to present it in evidence. The only way you could go around the rule is to prove to the court that it would be unjust not to present that evidence during the trial. Because the rule in our trials is this: you have to disclose every evidence during the pre-trial. That's why we have modes of discovery. Although it's not in your rules, because it is in Administrative Matter 03-1-09. It is also the same Administrative Matter which says that within 1 day from the filing of the complaint, the clerk of court is now going to prepare the summons together with a copy of the complaint, and there will be an order from the court for the parties to avail of Rule 25 and Rule 26. Other rules on discovery are discretionary, but you have to comply with Rules 25 and 26. Okay, now, when is testimonial evidence offered? Because you have to object when the evidence is offered. Answer, when the witness is called to testify. You're going to offer his testimony. Your Honor, my first witness is so-and-so, and then mention the personal circumstances. And Your Honor, his testimony is offered to prove the following matters. That's the offer. Then you begin asking questions to the witness. There are some courts who allow the offer after the testimony. Your Honor, my witness has testified, and his testimony is offered for the following matters. There are some courts who allow an after offer. But if your kalaban does not make an offer, do not remind him to make an offer. If he does not offer the testimony, that is not evidence at all. And that cannot be considered by the court because of Section 34 of Rule 132. See, we are rearranging the rules for you. Look at Section 34 of Rule 132. The court can consider no evidence which has not been formally offered. Did you get it? The court will not consider an evidence which has not been formally offered. That's the rule. If it is not offered, it is not evidence. But the Supreme Court has crafted out a rule that serves as an exception to this rule because of the liberal construction of the rules. This began in 1989. This is the case of People versus Napat Act, which had been repeated in various jurisprudence. What did the Supreme Court say? Sometimes evidence not formally offered may be considered by the court. If that evidence has been, number one, identified by testimony, then that testimony has been duly recorded, and that testimony has been incorporated in the records of the case. It is now a substantial compliance of the offer. But it will only be done by the court, according to the Supreme Court, if following strict technicalities will prevent the effective dispensation of justice. Because if there is a conflict between the technical rules and the interest of justice, justice has to prevail. In other words, the general rule is follow the rule, unless it will prevent the dispensation of justice. Halimbawa, yung evidence na yun, magpo-point out sa kanyang innocence, at talaga namang innocent in relation to other evidence, pero hindi mo na formally offer. Ibig sabihin, i-convict mo yung tao dahil sa hindi lang nasunod ang isang rule. Nasaan ang justisya dyan? Sabi ng Supreme Court, sundin natin ang justice. The rule will be suspended in that particular case. Okay? Now, you have to know when evidence is offered because that is when you are going to object. Okay, the wife. Your Honor, my first witness is the wife of the accused. Her name is so-and-so. She is Mrs. Riano. And her testimony is offered to prove the following, that it was her husband who really robbed Metro Bank. Blah, 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 blah. Okay, it is now offered. The husband will object for the counsel. Objection, Your Honor. The husband does not consent. Then you object. Now, if you do not object, the wife testifies, and then you cross-examine her, wow, the inadmissibility is weak. So, when it is offered, object. Objection, Your Honor. The husband does not consent. So the court will say, the witness is discharged. The objection is sustained. Because a wife cannot testify against me without my consent. Is that right? Oh, yeah. All right. When do you object to documentary and object evidence? Answer, at the time it is offered. When is it offered? Oh, object evidence and documentary evidence are offered after a party has completed the presentation of his testimonial evidence. You will hear judges saying, any more witnesses, Mr. Plaintiff? No more, Your Honor. We have concluded the presentation of the testimony of our last witness. And the court will say, make an offer. Yan. You can do it orally. The court may allow you to do it in writing. But there are three parts of an offer. The first is the designation of the exhibit, meaning, is it Exhibit A, Exhibit 1, etc.? Designation of the evidence, which in normal court practice would be considered the exhibits. Then, the second part is the nature of the exhibit and the purpose for which the exhibit is offered. Those are the three parts. You wait for this, because this will be the basis for the objection. The purpose for which it is offered. Sometimes, this is called offer of evidence. In ordinary court practice, they do not use the so-called formal offer of evidence. They use the words formal offer of exhibits. But they're the same. But the one normally used in ordinary court situation is formal offer of exhibits. But actually, it's a formal offer of evidence. It's like this, you know. If it is done orally, you also follow this format. Your Honor, I have no more witnesses to present. Court said, make an offer. Your Honor, my first exhibit is Exhibit A. Exhibit A, Your Honor, is a deed of sale. Nature. Deed of sale executed by the plaintiff and the defendant. The purpose, Your Honor, is to prove that the actual purchase price is 1 million and not 100,000 as alleged by the plaintiff. Objection, counsel? No objection, Your Honor. Exhibit B is so and so. Exhibit C is so and so. Any objection, counsel? No objection, Your Honor. So, no objection. The court will say, exhibits are admitted into the records of this case. Then you say something, Your Honor, with the admission of my exhibits, I rest my case. That's it. Then, if I were the defendant, tapos na ako, tapos na rin ang plaintiff, then the court will say, the case is over. Then the court will decide. Okay? When they object to the evidence? When the evidence is offered. When do you object to an oral examination as during the trial? When the objection becomes apparent, you object. What did he tell you, Mr. Witness, as to the one who killed who won? Objection, Your Honor. The question calls for a hearsay evidence. What did he tell you as to the killing of who won? Ibig sabihin, yung witness, walang personal knowledge, okay? Galing sa kaalaman ng iba. Objection, Your Honor. The question calls for hearsay evidence. Bago ka nakasagot ng objection ay nalulun mong laway mo. Nakasagot na siya. Your Honor, I move to strike out the testimony because the answer was hearsay. Strike it out. Yeah. Okay? Move to strike out, Your Honor. The evidence is not in relation to any issue of the case. In other words, Your Honor, it's irrelevant. Your objection, however, must be specific. Sasabihin mo, objection, Your Honor, parole. Objection, Your Honor, improper impeachment. Objection, Your Honor, leading. Objection, Your Honor, misleading. Pag wala ka na talagang maisip, objection, Your Honor, already asked. Objection, Your Honor, already answered. If your evidence is rejected by the court, what are you going to do? Do not panic. You make a tender of excluded evidence under Section 40. There is an official name for tender of excluded evidence. It is offer of proof. It's not offer of evidence, okay? It's offer of proof. Okay. Now, how do you tender an excluded evidence? Alam niyo, mga American lawyers, nung ako'y nagtatrabaho sa law firm nila, natutuwa pa nga sila pag na-exclude din. Kasi hindi naman ma-exclude talaga. Ganito yan. Hindi pinatestify ang witness. Bihirang gamitin sa Philippine courts to pero normal to in American courts. The witness was not allowed to testify. Ganito yan, Your Honor. My witness, Your Honor, is Audrey Murphy, Your Honor. Now the following are his personal circumstances. He's a veteran of the Second World War. He is, Your Honor, a recipient of the Medal of Honor. He is 95 years old, Your Honor. And Your Honor, if he were allowed to testify, he would testify on the following matters. Number 1, number 2, number 3, number 4, up to everything. And had he been allowed to testify, that would be the purposes for which his testimony is offered. Thank you, Your Honor. The court cannot say no. Anong napansin niyo? Yung testimony niya, ang substance, andun pa rin sa record ng case. Nakita niyo ako? Oh, babasahin ba yun ng court? Yeah, tao yan eh. Chismoso rin yan eh. Ano ba itong gusto niyang i-testify sana? O nandun, mababasa niya. Pwede pang madala ang kanyang emosyon. Wala pang objection. Pero umobject ka sa offer. Your Honor, I'd like to make a manifestation that even if his testimony is to be part of the records of the case because he invokes a tender of excluded evidence, Your Honor, it would still be irrelevant and has nothing to do with the issues of this case. Ayan, bumanat ka ngayon. To remind the court na kahit nandun sa records, irrelevant pa rin yun. You get me? You remind the court always because judges forget. Your reminders must be there. Are you objecting, Attorney Riano? No, Your Honor. I'm making a manifestation. Pero nag-object ka, sabihin mo lang manifestation. Hindi pwedeng wala sa records because every court in the Philippines is a court of record. You get me? That's psychology. So when you appear in trial, remember this, to be relevant, always use the issues of the case. Look at the pleadings. Now, how do you tender excluded evidence of a documentary or an object evidence? Oh, very simple. Your Honor, since this honorable court has not admitted my evidence, I therefore invoke my right to have it tendered and made part of the records of the case. The court cannot say no. That's Section 40. In Alabama, when I was asked to go there, I saw a different form of offer of testimonial evidence. It was very detailed. Your Honor, had our witness been allowed to testify, my witness would be described as so-and-so, and he would be asked first question, what is your name and other personal circumstances? Then he steps to the right. The answer, Your Honor, would have been blah, 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 blah. The second question, Your Honor, would have been, then he stepped to the right. And the answer would have been, because in Alabama before, it was so detailed. We did not follow the detailed one. Only the substance of the testimony is okay. Did you see that in Section 40? Yes. What again is my remedy if my evidence is not admitted in court? Answer. Make a tender of excluded evidence. What is the other name for tender of excluded evidence? Offer of proof. That's the other name. That's the official name.